Okay, debt collection letter or lawsuit. Now here we have our debt collection letter, and this letter is exactly what it purports to be. It's a letter, and it's a threat that they may file a lawsuit. Okay, notice of intention to incur court costs and legal fees by filing suit. This letter is designed to scare you, and if you call and offer a settlement in response to this, you will usually get a demand of 100% of what they claim, or maybe 90%, and you quite often will not get a good deal. You can go ahead and call in response to this, but just keep in mind this is not a lawsuit, and technically there is no obligation for you to respond. Now, this is a little bit different. This is a summons. A lawsuit starts with a summons and a complaint. There are two different documents. I'm not showing you the complaint because complaints look a couple different ways, but summons always look exactly like this. It says summons at the top, notice to defendant, you are being sued by plaintiff, your name would go here, plaintiff's name would go here, and then there's information about where the courthouse is located, and then there's information about the attorney that's representing the debt collector or the owner of the debt. Okay. Now, if you receive the summons, you need to respond. We recommend that you respond because if you do not respond, you could lose the case. You have 30 days to file a formal response called an answer to the complaint. You can file other documents as well, but quite honestly, most of the time you're going to want to file an answer. You start counting your 30 days from the date that the summons was delivered to you or another adult at your home or work. Your 30 days is not counted from the date stamp. Alright, so right here you may see a date stamp. That is the stamp that the summons was prepared and issued to the plaintiff, but that's not the date that you were served necessarily. Maybe they rushed over and served you on the same day, but you don't automatically count this date, okay? You count 30 days from the date that it was delivered to an adult, to you or another adult at your home or your work. Now, answering the complaint. A letter or a telephone call is not an answer. Asking for more time is not an answer. And explaining that you're really a good person and you lost your job and it's really not your fault that you can't pay, it's not an answer. Now, I appreciate all these positions, and I've heard plenty of clients go through these motions. But keep in mind you have a 30-day deadline and you have to file an answer. And it is not enough to just call them and talk to them unless you absolutely settle the case and it's over. We recommend filing an answer. An answer is a denial. A proper answer denies that you owe the debt and requires that the debt collector prove every aspect of its case. It is how we do things in the legal field. They claim you owe money, you deny it, and then in court we see who has the proof. Answer the complaint before you show up at any hearings. Now, you may get notice of a future hearing, and that's fine. Put that on your calendar. But you have to comply with that 30-day deadline and file your answer. If you just wait a couple months and wait for the hearing to come and just show up, the judge may not even let you speak at all. If you do not file your answer to the complaint within 30 days, you may lose your case long before you ever get a chance to speak to a judge. Now, look, it's not that hard. You can actually save a lot of money by putting up even a minimum defense. And you can buy yourself time to negotiate a much better settlement than they're demanding up front. And in some cases, you can get the case dismissed without paying the other side at all. We at the Fullman Firm can help. We have low-cost alternatives, and you get assistance from real lawyers, and we know what we're doing. Give us a call. Everybody gets 10 minutes for free.